Hi, I'm attorney Ray Hassett. I'm here with attorney Felicia Hunt. We're with the law firm of Hassett and George. We'd like to thank you for joining us today on this brief webinar. We've gotten a lot of questions from professionals, counselors, mental health professionals saying, what's going on with the court system and what's the future look like? And the short answer is we don't know exactly what the future's like, but we know where we stand today, and we have a pretty good guess as to where we're going to proceed. And there's also been some innovative forms that are being proposed by the court and procedures so that we can actually get things done, including uncontested divorces, which we'll talk about in a little while. We're unquestionably in uncharted waters at this point. Having the court systems closed down for this time has never occurred in my 30 plus years of practicing, with the exception of maybe a snow day here or there. I'm sure you're finding it difficult too. We're communicating with clients predominantly through phone and through teleconferencing, and sometimes that's very impersonal and difficult, but at the same time, it's what we're using to facilitate communication and to move matters along. More than ever, we as lawyers have to work closely with you, mental health professionals, and co-parenting counselors and counselors in general to help our clients. They need all of our coordinated assistance. We need to collaborate together, and we're hopeful that this brief webinar gives you some information that may be able to be helpful to both you and to your clients for at least the foreseeable future. Again, things are going to be changing on a daily basis, but as it stands right now, we're going to give you a good idea as to where things presently are and where they will most likely be. So this all started back in April. The courts were closed back on March 12th, pursuant to a judicial decree and an executive order. And they were closed effectively just to what we consider what were called Priority 1 business functions. Those Priority 1 business functions were being maintained and being heard in all courthouses. Eventually, on March 19th, that stopped as well, and there's only a limited number of courthouses, 3 or 4 that are open throughout the state of Connecticut to handle these Priority 1 cases. What are these Priority 1 cases? Well, effectively what they are cases that the court system finds that the safety and the well-being of both the litigants and children and those involved in family court is so essential that it needs to be heard, and we need to have some opportunity for people to present their cases and have some judicial ruling. And for the most part, they deal, again, with safety, such things as criminal arraignments, individuals that are being arrested. They have legal rights that automatically attach as soon as they're arrested, presentment, bond, things of that nature, so they're being heard. In the family court matters, we're seeing that juvenile court detention hearings are in fact being heard, family court orders, relief from stay, relief from abuse rather, relief that people are seeking because of extenuating circumstances having to do with their liberties, their safety, and their well-being. So ex parte motions are in fact being heard. Temporary motions in the juvenile court are also being heard, as well as termination of parental rights, domestic violence cases, things of that nature. By the way, a list of all the Priority 1 business functions, these cases that are being heard, is on the judicial website. For those of you that are interested, you can just Google Connecticut Judicial Department. The website will come up, and you'll see that there is a whole section, a predominant section as you open up the website, dealing with this COVID-19 situation. It's very helpful, gives you some information and instruction. So right now the courts are basically stuck with and limited to these Priority 1 cases. What we're seeing as practitioners are situations, for example, parents that live in separate homes have a parenting plan, and they are not exchanging the children in accordance with the parenting plan. One or both parents is having difficulties and blaming the COVID-19 situation for not exchanging children rather. And as a matter of fact, the courts have almost uniformly denied most of those motions and said you have to stick with the parenting plan. Of course, if there's a safety involved or there's extenuating circumstances, I know a number of attorneys that are getting certifications and letters from physicians indicating why parenting plan should be changed at this time. Those are being submitted to the court. But for the most part, the courts are in fact saying, look, don't come to us if you're just concerned about the COVID-19 situation. You really have to have some basis for it as well. Certain states, for example, California has issued an across-the-board order that basically says just that. The existence of COVID-19 is an insufficient basis for modification alone. You need to articulate facts and circumstances that justify a modification. And they've put in force certain mechanisms. For example, parents that have a public location where they exchange children, they can't go into that public location, a McDonald's, a library, something of that sort. They're doing it now in order to do it in the parking lot. So there are ways and mechanisms that we can try to facilitate the existing parenting plans. There's a degree of reasonableness that parents don't always have when they're fighting over their children, in which, again, you're on the front lines with. We have some mechanisms and maybe some language that can be used to facilitate that. But for the most part, until the courts reopen and we can get additional court orders, these situations are going to be left in your hands to deal with, which we're happy to help you with. We are seeing people remotely. Some people are actually even willing to come into our office and sit down and confer with us. Obviously, the masks, the gloves, the whole protocol we follow to the level of comfort that people are requesting. We obviously do that. Remote teleconferencing, telephone calls. We're seeing people too, as I'm sure you are as well. So the courts right now are attempting and efforting to, in fact, implement some procedures so that we can move business along. And that's very important to note. I'm going to turn it over to Felicia Hunt. She's going to give you some information that will facilitate our ability to help and assist in getting additional court orders and even to get a fully uncontested divorce finalized today. We can do that without court appearances, so I'll turn it over to Felicia.
Thank you, Ray. I am Felicia Hunt at Hassett and George with Ray, and we are trying to communicate to clients and other professionals that the court closures and limitations do not mean we can't make progress on cases. Whether we have a family who recently filed, who is hoping to file soon, or has a new post-judgment issue that needs to be addressed, there's substantial out-of-court process that can move those cases forward to resolution. Hopefully, these limitations on court, in fact, will motivate and inspire additional compromise and even fully resolve the cases to enter a final agreement. As Ray said, uncontesteds can now be entered all the way through final judgment without any court appearances, which I'll talk about that more in a moment. And even in the long run, when the courthouses do start to open up after at least June, probably late summer, even early fall, we anticipate that it will be gradual only, unfortunately, both in terms of the number of courthouses per district and the capacity of cases for each one. It will go through phases, just like everything else we're seeing out there with businesses and such. So it's going to be a long, slow road back to the usual flow of business. So we're strongly encouraging our clients and our colleagues, like the mental health professionals, to reshape how we move cases forward. So it's important for them and you to know that we don't have to wait. We can move the cases forward now. We can help them move their lives forward now. So for those inevitable cases that can't resolve all issues, I just want to comment, that's okay too. We can reach agreements on some issues, hopefully most, and even enter a partial agreement with a later check back date and even a hearing if necessary when the judges are ultimately available. So in terms of process and how we get there, the court, even before the court closures, did have a process for entering a temporary stipulation ordered without a court appearance. There's a special form that was filled out by the parties, the lawyers when present, and the court would take a look at that remote or online on the e-filing system and approve those agreements. That has now been expanded, and now that will work for our post-judgment matters. Certainly the temporary matters, for example, a temporary parenting plan, temporary financial orders, and the like. And the stipulation will then be signed by the judge and re-uploaded online on your case docket. So then you have your court order available to move forward and institute those changes in everyday life. In addition to the court now accepting post-judgment orders, which is a final order, even after the divorce or the custody order has been entered, they are now instituting a process whereby the uncontested dissolutions can be approved without a court appearance. And this is significant because the previous process that was in place for non-adversarial divorces were limited. They were only for cases without children, and they were only for cases under a certain amount of income and then a number of assets. So now this new process allows an opportunity for all families for their agreement with children, with any income level and any asset level. So in order for the court to facilitate this, they have rolled out a number of new forms that go along with it, including an approval or a request for approval of that agreement and affidavits by each party acknowledging that they've gone through the agreement and that they understand the various statutory requirements and the like to confirm their review and understanding of the agreement without having the benefit of in-person canvass by the judge. So these forms do require notarization on a number of the pages. There's an executive order allowing remote notarization as well. So put all the pieces together, we really can move these families from start to finish. Or if they're halfway through, we can bring them to the finish line. So the point for the mental health professionals to understand with all this knowledge of new court procedures is really that we can do this. We can help these families through. We can get them to the end at any stage before the case is filed, beginning stages, ending stages, even after a dissolution. We have the tools now, as of last week, actually, a few days ago, we had this new opportunity to get these cases, to get business done. But the key is we're going to have more cooperation outside of court, which is where we need as much help from our group of professionals as possible to help them do that successfully.
As Felicia just said, as a matter of fact, she filed one of the first uncontested divorces without a hearing form and format. We're waiting to see how that works out, but she filed one of the first ones in the state. We're confident that it's going to work out in accordance with the mechanism that has been set up by the judicial branch. What we're trying to do is we're trying to avoid people from becoming overly anxious about the divorce proceedings to going to extremes. An example is we had a client that actually contacted the police when the children were not exchanged in accordance with the parenting plan. The excuse was the COVID-19 situation. Police actually got involved and threatened to arrest the parent that was unwilling to provide the children in accordance with the parenting plan to the co-parent. And as a result, police involvement really exacerbated things. We're trying to avoid those things, but if necessary, we do have those options available from a legal perspective that we can at least advise people of. But again, the future's uncertain, the future's unknown. We're anticipating that the court systems will be reopening somewhere around May 20th, 21st, and it will be a gradual, slow startup with a phase-in. Whether people are going to be required to attend court in masks and gloves and taking personal protective equipment with them, we anticipate that may happen in the very beginning. We're told that jury trials have not been scheduled and will not be scheduled until after January 1 of 2021. So the court system has a phase-in anticipated that will take time for us to get back to the processes and the procedures that we're used to. We are also filing motions for people so that we can effectively get in line when the courts open. I think a number of family law practitioners have done that. So there will be an awful lot of litigation that will be occurring, I presume, once the courts reopen. All the court trials that have been scheduled for May and June have been canceled effectively, and they're going to be rescheduled. Those probably won't happen until late fall or into the winter. So there's going to be a lot of juggling, and a lot of uncertainty creates a lot of unrest for our clients and for the individuals that you're seeing and helping. We are here as a resource. We're here to offer suggestions. There is collaborative means that we can use and utilize in conjunction with you, and we hope to be able to offer those. If nothing else, just call us and we can make some suggestions if you need it. Most of you are very well experienced and qualified and can figure out how to do this on your own, but to the extent that you need any help, we are here. We intend to do some webinars in the future as well. We're open to any suggestions you may have. We've already gotten a few, and we have a few ideas of things we're going to put together for you. Again, feel free to reach out to us. Any questions, our number is 860-651-1333. You can either ask for myself, Ray Hassett, or for Felicia Hunt. Until we see each other, Stay safe.